I would like to make a few points as we wrap this up. The first is I would react to the comments of some of my colleagues that Democrats want to pack the court. My sense is the court has already been packed. It has been packed as the result of a very long and expensive effort run by a handful of secretive right-wing billionaires through a bunch of front groups. The tally of the cost of the operation has risen from the original $250 million estimate of the Washington Post to now $580 million spent on trying to make sure that those billionaires succeeded in what has been characterized in this room as the long effort to make this a conservative court. The question of whether or not it is appropriate for lower court judges to stand in some degree of judgment over the administrative question of whether or not there's compliance with rules is actually the current state of the judiciary. That is the way it works right now. So objecting to that is objecting to present reality. Let me start by pointing out that there are two sides to a judge's job. One is the judicial side, adjudicating matters, and the other is administrative side, which includes the ethics part of a judge's job. You have a clue which role the judge is playing if they're wearing a robe. If they're not, it's very likely the administrative side of their work. In the administrative side of their work, where the ethics questions are handled, those determinations go to the judicial conference. That's the same body I mentioned earlier that was established by Congress and that implements the financial disclosure laws passed by Congress and the recusal laws passed by Congress. It is made up essentially entirely of lower court judges. One justice sits on it as chair, the Chief Justice. And questions about financial disclosure of the justices are sent there now. We know that because we've seen it happen. In the first round of Harlan Crow to Clarence Thomas yacht and jet free travel disclosures back in 2011, that was sent to the Judicial Conference and to its Financial Disclosure Committee. Its Financial Disclosure Committee is composed entirely of lower court judges, circuit chief judges and district chief judges. That is who resolved the matter of that first round of gifts from Harlan Crow to Clarence Thomas. And the second round, right now, that the Judicial Conference is reviewing was again sent to the Financial Disclosure Committee, again made up entirely of lower court judges. So the objection that lower court judges would make a determination about whether justices have complied, for instance, with financial disclosure rules, that's the present state. That's the present state. And the other question that went before them recently was this question of Justice Scalia's maneuver, you want to call it that, of reading a personal invitation from a resort owner with whom he had no personal relationship as a matter of personal hospitality. When that question went back for determination, it went back to the Judicial Conference. And it was the Judicial Conference made up of lower court judges that said, no, that doesn't fly, that is not legal, that is not what the personal hospitality disclosure rule permits. So thank you for letting me have a chance to make that record. I don't know if we have the... I don't know if I'm holding up a vote at this point. Nope, not yet. Okay, we're still waiting for people to come back from the voting. So, you know, there are a lot of canards that are flying around in all of this. The canard that lower court judges can't make decisions about the administrative side, the ethics piece of Supreme Court justices' behavior is just simply belied by the fact that it has happened exactly that way over and over and over again, and without objection. Without objection. When Justice Thomas's first round of secret yacht and jet gifts from Harlan Crow was referred to the Financial Disclosure Committee, he did not say, wait a minute, you can't send that to that body. They're all lower court judges. He went along with it. And no Supreme Court justice has ever complained about lower court judges through the Judicial Conference exercising their judgment about administrative, financial, and ethics matters. So that just ain't so. And the argument that we are up against an attack on the independent judiciary and that this violates separation of powers, again, is belied by the acts of the justices themselves. The Judicial Conference has existed for decades. The court knows it exists because the Supreme Court Chief Justice chairs it. They have never objected to that being an intrusion into separation of powers because it was established by Congress. And the financial disclosure rules that Congress established. Again, when the matter about the first round of Harlan Crow to Justice Thomas secret yacht and jet travel gifts was sent to the Judicial Conference, nobody said, you can't send it there because it violates separation of powers. They didn't say you can't do it because it's lower court judges, and they didn't say you can't do it because it's separation of powers. And that's because both of those arguments are completely false. There are ways to solve this problem that work squarely within the constitutional principle of separation of powers, a principle that I revere. As one of my Republican colleagues said today, there's also the question of checks and balances, and that we have to allow power to check power. Allowing Congress the power to check abuses in the judicial branch is a long established and proven fact that the Supreme Court has for decades gone along with without complaint, even when, and perhaps particularly when, it involved justices themselves. And indeed, after the Judicial Conference said, nope, you cannot fake personal hospitality if it's a corporate venue. You cannot fake personal hospitality just because it's a personal invitation. You cannot fake personal hospitality if there's not a real and long-standing personal relationship. When they said that, they were exercising powers given to them by Congress. And there was no objection to that from the Supreme Court. Indeed, Thomas put out a rare statement saying he would abide by that. He did not say that's unconstitutional. He did not say lower judges shouldn't do that. He did not say there's a separation of powers problem here. He said, yep, I will follow that new rule.